Hello, and welcome back to the reading of White Rage, the Unspoken Truth of Our Racial Divide. If you've been reading along, we have been working through this book chapter by chapter, bit by bit. There are some parts in here that are a little bit heavy, so we are taking it um, as we need to have the time for the discussions, to have the time to think about what comes up, and to really work our way through the book. This book is really important, um, talking about the history and also relating to what we're dealing with today. So I want to thank you for being with me. If you are hearing this, you are a part of the Patreon community. So I thank you for being a part of that as well. And just a reminder, feel free. And I'm encouraging you, if you want to use Patreon and the comment section from these posts to discuss anything that comes up. Ask me any questions, discuss with the other people in the community, but really take advantage of that should you want to really kind of work through this book. I think it's really important as part of the decolonizing journey. If you have been reading along, we are on page 148. We are in the first full paragraph. The chapter is How to Unelect a Black President, and it's chapter 5, I believe. And then we're talking about Barack Obama, how to unelect the Black president. Barack Obama's election was a catalyst for a level of voter suppression activities that had not been so clearly or disturbingly in decades, that had not been seen so clearly or disturbingly in decades. Nowhere was this more apparent than in the Supreme Court's 2013 gutting of the Voting Rights Act. The case began in 2008. Shelby County, Alabama commissioners, though required by Section 5 preclearance of the VRA to receive approval from the U.S. Department of Justice before making any changes in election procedures, voting qualifications, or district boundaries, annexed several subdivisions of the city of Calera, and then, in direct violation of the VRA, redrew the district boundaries of the lone Black councilman, Ernest Montgomery, reducing the percentage of African Americans in his precinct from 69% to 29%. He lost the election. Attorneys from the NAACP Legal Defense Fund alerted the Department of Justice, which then required Shelby County to hold another election using the original district boundaries. The commissioners balked. Quote, federal oversight was no longer needed, they asserted. We've made progress, end quote. In 2010, Shelby County filed suit in federal district court, charging that Section 5 of the Voting Rights Act was unconstitutional because Congress did not have the authority to reauthorize the act of 2006. The district court disagreed, as did the U.S. Court of Appeals in 2011. The judges were unequivocal. Congress drew reasonable conclusions from the extensive evidence it gathered and acted pursuant to the 14th and 15th Amendments, which entrust Congress with ensuring that the right to vote, surely among the most important guarantees of political liberty in the Constitution, is not abridged on account of race. In this context, we owe much deference to the considered judgment of the people's elected representatives. The U.S. Supreme Court looked at Shelby County's clear violation of the law and, in a 5-4 decision penned by Chief Justice John Roberts, came down squarely on the side of the commissioners. In Shelby County versus Holder 2013, Roberts and 4 other justices treated the rationale for the Voting Rights Act as now obsolete. They conceded the past terror and the pernicious laws that had resulted in millions of African Americans being disfranchised. But it was a new day in the South, Roberts wrote confidently. Largely because of the Voting Rights Act, voting tests were abolished, disparities in voter registration and turnout due to race were erased, and African Americans attained political office in record numbers. Although that success should have led the court to conclude that without the protections of the VRA, those changes could easily be erased, that success instead led Roberts and 4 of his colleagues, including the lone Black justice on the court, Clarence Thomas, to veer in the opposite direction, asserting that because the law has worked so well, and because other states aren't held to the same scrutiny, the act, as reauthorized by Congress in 2006, was out of sync with modern times. With that, the justices kept Section 5 but declared unconstitutional Section 4 of the Act, which provides the conditions under which the Department of Justice may place a jurisdiction under the oversight stipulated by the statute. How the court arrived at that decision is a testament to twisted facts and ignored evidence. Roberts, for example, contended that the VRA placed burdens on jurisdictions because of past misdeeds that could not be justified by current needs. The so-called burdens he alluded to, however, were borne only by those jurisdictions with a long, well-documented history of discrimination and a systematic pattern after the initial passage of the Voting Rights Act in 1965 of trying to craft laws that violated the basic right to vote for all citizens. Locales that required Department of Justice scrutiny had a nearly 50-year history after the VRA of continued attempts to discriminate. In fact, the act contains a bailout provision wherein the federal government no longer needs to monitor what a jurisdiction does. Indeed, the bar to achieve bailout status is not all that high, requiring a jurisdiction to abide by the law for an appreciable length of time, following which the extra scrutiny of the Voting Rights Act no longer applies. Numerous counties in Virginia, as well as North Carolina's Wake County, Georgia's Sandy Springs, Texas's North Austin, and Alabama's Pinson, having met the standard, have been thus bailed out. The fact that the majority of other locales in the old Confederacy, in the heart of what is now GOP country, have not says more about the tenuousness of the right to vote than it does about the rigors of the Voting Rights Act. Moreover, the court's depiction of the Votes Rights Act is unduly discriminatory against the South, and static is wrong on both counts. First, over the years, the Department of Justice has had to bail in other districts throughout the United States because of racially discriminatory laws and policies that have blocked equal access to the ballot box. This includes 8 counties in Arizona, 1 in Idaho, 4 jurisdictions in Alaska, 2 in California, 3 counties in New York, and 1 in Wyoming, as well as towns in Connecticut, Massachusetts, Maine, and New Hampshire. Discrimination has never been just a Southern phenomenon, and the VRA has recognized that. In short, the vigorous use of bail-in and bail-out provisions utterly undercut Roberts' contention that the law is an ancient artifact that somehow does not address current needs. Beyond the fact, this is a lot of words to say that the Voting Act, a lot of words and a lot of actions for the people to say the Voting Act was not meeting current needs. But the question prior to that, because if you've been with me here or on social media, is I like to get to the root cause of things. If they weren't necessary for current needs, if they weren't meeting current needs, why was there so much work? And we know the answer to this, but why was there so much work to get rid of it? When I say that agents of white supremacy are busy, this is an example of it. They are busy doing everything they can to keep white supremacy at the forefront, to keep these layers of oppression. If the Voting Rights Act was not a problem, then it should have been left alone, right? That's as cut and dry as we can make it. The same thing is that if politicians and citizens weren't threatened by the African American, Black American vote, if they didn't feel concerned by what having Black Americans voting would do for policies and laws and having people in office and people in positions, if they weren't concerned about that at all, then nothing should have been left alone. It lets you know that these little small steps that are given to Black Americans as little crumbs are merely just crumbs, and they're often things that can be wiped away as you would with a crumb or a mess. Wipe it away like it was never there. It's important to pay attention to the thing behind the thing, get to the root issue. Moreover, the court's overriding concern that the law is somehow anti-South, while sounding strangely similar to John Mitchell's argument in 1970, willfully overlooks the region's continuing attempts to silence Black voters. Discrimination did not stop in 1965, nor in 1975, nor in 2005. Since 2011, 9 of the 12 states of the old Confederacy, according to the NAACP, have adopted or proposed 2 or more requirements to tighten access to the polls, such as placing restrictions on voter registration drives and requiring a government-issued photo ID to vote. The only thing keeping the wolves at bay during that time was a Voting Rights Act pre-clearance provision. The Supreme Court's ruling in Shelby County versus Holder, however, turned the dogs loose. Immediately following the ruling, Arizona, Arkansas, Florida, Iowa, Kansas, Mississippi, North Carolina, Texas, and Virginia all passed a compendium of voter suppression laws. By the following year, right before the 2014 midterm elections, 13 additional states had passed voter restriction statutes. All were under the guise of protecting the integrity of the ballot box but all had the intent of limiting and frustrating voting by African Americans and now Latinos too. The only recourse available was to take those states to court and demonstrate the discriminatory intent and effect of their electoral policies. This is exactly how Richard Nixon and his attorney general had hoped to gut the VRA in 1970. The long, litigious delays meant that, unlike the days of a robust and fully functioning Voting Rights Act, which prevented discrimination before it could do damage, the courts would now come in only after the fact. Texas is a case in point. Almost the moment Shelby County versus Holder was announced, the Republican legislator put through a highly restrictive voter ID law, SB 14, a phalanx of civil rights organizations, including the NAACP and the League of United Latin American Citizens, Minority Voters, and Mexican American Legislative and Hispanic Judges Associations, immediately sued the state of Texas. During the 2-week trial in the fall of 2014, the Attorney General of Texas, Greg Abbott, argued that the law was necessary to stop and prevent rampant voter identification fraud. To stop and prevent voter identification fraud. Let's think back to Ronald Reagan, who created a drug crisis so then he could create the war on drugs, creating a problem to fix the problem to seem like the hero. There has been no problem, or the problem that has been conflated to be such a huge issue with voter identification fraud that has been completely blown out of proportion so that politicians that want to have voter restrictions can create a problem to then fix. It's very manufactured. Yet out of 10 million votes, he could produce only out of 10 million votes, he could produce only 2 documented cases of voter impersonation. On the other hand, it became clear that nearly 600,000 Texas, mainly poor, Black, and Hispanic, didn't have the newly required IDs and often faced financial and bureaucratic obstacles in obtaining them. Thus, in September 2014, in a stinging dressing down of the state, District Court Judge Nelva Gonzalez Ramos ruled that Texas's voter ID law, quote, creates an unconstitutional burden on the right to vote, has an impermissible discriminatory effect against Hispanics and African Americans, and was imposed with an unconstitutional discriminatory purpose, end quote. Texas, she emphasized, had levied an unconstitutional poll tax on its citizens. Ramos's ruling, which declared that Texas had deliberately created discriminatory voting requirements, was a tripwire to reinstate the Voting Rights Act's Section 5 preclearance statute in Texas. The state, therefore, intended to fight the decision. Their first order of business, though, was to seek immediately a judicial delay to allow the voter ID law to remain in place during the upcoming midterm election. Chaos would reign at the polls, argued Texas Attorney General Abbott before the Fifth Circuit Court of Appeals, where the law changed this close to an election. He would also assure the court that keeping the voter ID law in place would not, quote, substantially injure the plaintiffs. This is so much work to stop voices. There's so much work to stop voices. On October 14th, 2014, the Fifth Circuit judges agreed and granted Texas's request to allow a deliberately discriminatory law to operate during the all-important midterm election. As the judges saw it, quote, this is not a run-of-the-mill case, and Ramos's ruling substantially disturbs the election process of the state of Texas that just 9 days before early voting begins. Thus, the value of preserving the status quo here is much higher than in most other contexts, end quote. The U.S. Department of Justice, civil rights groups, and individual voters then joined together and raced to the U.S. Supreme Court, seeking to overturn the Fifth Circuit's ruling. While the U.S. Supreme Court, led by Justice Antonin Scalia, ruled in favor of the state without any comment on the merits of SB 14, Justice Ruth Bader Ginsburg's dissent was incisive, tearing away at the supposed chaos that might occur in the election if the discredited voter ID law was suddenly just jettisoned. There is little risk, she wrote, of disrupting the election process. All Texas needed to do was reinstate the voter identification process it employed for 10 years, from 2003 to 2013, and in 5 federal general elections. After all, she observed, the new state requirements for voter ID had only been used in 3 state elections where the voter turnout ranged from 1.48% to 9.98%. While those Texas primaries were relatively low stakes, Ginsburg noted, the November 2014 election, quote, would be the very first federal general election conducted, end quote, under the new voter ID regime. And that was a problem. The Supreme Court, she wrote, could not allow a purposefully discriminatory law, one that likely imposes an unconstitutional poll tax and risks denying the right to vote to hundreds of thousands of eligible voters, to be used in a federal election. But that is precisely what the U.S. Supreme Court did. After the election, the case went back to the Fifth Circuit Court of Appeals as the U.S. Department of Justice, civil rights groups, and a number of voters sought to invalidate SB 14 once and for all. In August 2015, the Federal Appeals Court panel's deliberations focused on whether the legislator had actually intended to create a statute so blatantly discriminatory. The question of intent was central in determining whether Texas would have to undergo Section 5 preclearance scrutiny again. In a decision that fully satisfied neither of the parties, the panel of federal judges ruled that the Texas legislature had not set out, in fact, to write a law that discriminated so clearly against Hispanics and African Americans. However, the jurists continued SB 14, the state voters ID law, did violate what was left of the Voting Rights Act. Confronted with being chastised for massive disfranchisement, Greg Abbott, the newly elected governor and former attorney general, continued the fiction that this law was about the sanctity of the ballot box. Quote, Texas will continue to fight for its voter ID requirement to ensure the integrity of elections in the Lone Star State, end quote, he declared. Attorney General Ken Paxton, for his part, defiantly stated that the ruling would not undermine the, quote, fundamental question of Texas's right to protect the integrity of our elections, adding that our state's common sense voter ID law remains in effect, end quote. Despite all this bluster about the integrity of elections, however, there wasn't any. It was clear that between Judge Ramos's decision and the Fifth Circuit's ruling, as one civil rights advocate noted, we've now gone through a federal election with this discriminatory voting law in place. There's some more to this chapter that I think we're going to pick up on. We can probably finish this. Okay. In addition to, this is going to finish out chapter 5. I was looking to see how long we have. In addition to blocking access to the polls, the GOP's strategy is to make the very function of government so tasteful and haphazard that only the most diehard idealist or craven partisans would even bother to vote. You know what? I think I do want to pick this up next week, because this is going to go more into Obama himself as opposed to what was done to try to keep him out of office. They're both important conversations, but I want to keep them a little bit separate, because you have the initial part of the attempt to stop Black people from doing really anything, and trying to go at it the legal route, trying to go at it the governed route by lying or being less than truthful about why these attempts were made to stop voting, when it really comes down to the silencing of Black voices and also Latino voices. And like I said before, to work that hard to stop a voice, to work that hard to stop hearing what people have to say, that's intentional. That is very intentional. When people don't want to hear something that is not centering them, when people want to hear things that have to address the way that racism and white supremacy show up, when people don't want to hear these conversations, they will do what they can to stop them. If we're talking about a day-to-day person that's not in politics and doesn't have anything to do with governing law, they'll walk away from a conversation. They will stop a conversation. They will step in to refute what's being said or try to derail the conversations because they don't like what's being said. They don't like what's being done. When you have people in power, they will enact laws to stop what's being done because they don't like what's being done. And these are all responses, again, to the fact that it's not been about equity. It's not been about equality. It has been about doing the very bare minimum to try and convince Black Americans that we are welcome, that we're cared about, that we have any rights, that we matter, that anything that we have to say matters. All of these, again, crumbs that are being thrown our way. I want you to, we're going to continue on with the same journal For the journal prompts, I want you to continue thinking about how history is a continuation of itself, especially with the election coming around the corner, and especially with voting coming around the corner. There's been a lot of conversations around voting that are very important. And I think that it's also important to remember the historical way of how we got here, the ways that voices have been trying to be silenced, while under the guise of saying, yes, you can vote. So remember that, keep that in mind, as you're journaling. And I really want you, again, to think about, this one has me stumped today. Not my journal prompt, but I'm not stumped my words. I think that I'm coming from a place of just slight frustration with everything today, and I don't have to apologize for that. And I don't want you to apologize for feeling that way either. I want you to think about the continuation. The big thing I want you to think about is how we got here. The voting, the way that voting has tried to be stripped, the right to vote has tried to be stripped from Black Americans and Latinos, the way that has been actively worked at to shut our voices down. I want you to think about that. I want you to really consider how much work is done to make sure that we're not heard, while also expecting so much work to be done. Those two things don't make sense, and that's what we see the continuation of. We can see that, that it's wanted for us to go out and vote in droves and to do the thing that's right for the country. But then when you also think about how politicians and courts are doing so much to stop our voices from being there, it can be easy to say, well, yes, why wouldn't you fight back against that? Why wouldn't you do the most that you can to vote? I want you to think about what comes on the other side of that fight. What can happen? What can happen physically to us when we have that fight? What can happen emotionally to us when we have that fight? What can happen mentally to us when we have that fight? And while you're thinking about that, I want you to understand this is not for me to say that anybody is not going to fight because it's been so hard before. It is to open up your mind to think about what is behind, or what could potentially be going through the minds of people that have been so historically disfranchised, especially when it comes to the right to vote. Next week, we'll pick up with the finish of chapter 5. We're going to talk again more directly about Barack Obama, as this is unelecting the Black president. And then we'll roll into the epilogue. So we're just about finished with this book. And we've done some really good work. I mean, the epilogue is going to take us a while to get through, but I'm proud of us. And something to kind of think about too, we're going to keep this going with the book readings and discussing things. The next book that I have in mind for us is My Grandmother's Hands. It's another heavy-ish book, but it's not so much about the historical things and the way the history translates over, but it is about race relations, and what that looks like, what that can look like for Black people, white people, Indigenous people, the people of the majority. So it's my Grandmother's Hands. I'm letting you all know this now. Should you want to read along so you have time to get the book. If you don't want to get the book, that is perfectly fine. We will have it here. In the meantime, again, I am proud of you. I'm proud of you all for going on this journey. Again, use the comment section on Patreon. Ask me any questions that you might have. Bring up anything that you might want to discuss, whatever the case may be. This does not just have to be me reading the book to you. This can be an open forum and an open discussion. All right. I will see you all next week. And in the meantime, take care of yourselves.